Welcome to this VWV Procurement in Action podcast. In this podcast, we discuss the new rules on exclusion under the Procurement Act. I'm joined by my colleague Isabel West, who is a solicitor in our procurement team. Isabel, this is one of the areas that was subject to heavy scrutiny as the procurement bill went through Parliament. Are you able to explain the background to the changes?
Yes, so the concerns were initially raised in the Green Paper consultation. So the feedback was sort of that the current regime isn't clear or simple enough. So the government sort of sought to make it clearer, make it simpler, but also try and toughen up the rules a bit to stop companies who have bad track records or bad performance from continuing to win contracts. So a real life example was the collapse of Carillion in 2018. So they were sort of renowned for their aggressive accounting, but despite this, they still continued to win pretty big contracts. So I think at the time of their collapse, they were party to about 450 contracts. Wow. So it had a massive impact, obviously, on the industry. So hopefully this new Procurement Act, specifically these regulations, will sort of stop things like this happening again.
And so if you had to summarise the key changes that have been brought about under the Act.
So the main changes actually are to do with the exclusion and debarment regime.
Okay.
So they're really big changes that local authorities and suppliers are going to have to get to grips with. Obviously the debarment list is a big new thing. So it's basically making harsher consequences for these excluded suppliers.
Okay.
Because it's going to be a public list.
Isabel, we're going to talk about a scenario about how you might exercise the rights of exclusion to make it practical. But can you highlight some of the key changes?
Yeah, so there are quite a few key changes in this area. And the changes are going to affect both the contracting authority and the supplier side.
Okay.
So it's really important that people get to grips with the new changes early on. So the main thing basically is that the new rules are going to create a wider scope and a wider discretion to exclude suppliers. But it's also going to sort of bring into that scope connected persons and intended subcontractors.
Right.
So we can discuss that in a bit more detail.
Well, that brings us very neatly on to the changes in terminology.
Yeah.
In these podcasts, we've been talking about the new terminology that has been introduced by the Act. So can you talk me through some of the changes that contracting authorities need to get to grips with in this particular area? Yeah,
so in this area there is quite a lot. There is quite a few changes. So the key ones are sort of the debarment list. So this will be a public centralised list where excluded or excludable suppliers will be put on.
So you mentioned the references to excluded and excludable just then.
Yeah.
Can you talk me through those new terminology?
Yeah, so these are some key terms to get to grips with. So an excluded supplier is a supplier or a connected person, that's a key point, who meets a mandatory exclusion ground, which is likely to reoccur again, or they're on the debarment list for being an excluded supplier. So an example of a mandatory exclusion ground is something like fraud, bribery, tax evasion. So a lot of these are similar to what we have in the current regime, but there are a few changes that we need to be aware of. So something like competition law infringement. So if there's been an actual infringement, this will be a mandatory exclusion ground. But if there's a potential competition law infringement, this will be a discretionary exclusion ground.
Discretionary excluded ground, that's the new meaning of excludable.
Yes, an excludable supplier or their connected person, again, is one that meets a discretionary exclusion ground, which is likely to reoccur again, or they are on the debarment list for being an excludable supplier. So again, some examples of being an excludable supplier: past performance. So this was in the current regime, but they've changed the scope of that again. Breach of contract, environmental misconduct, things like that.
So you mentioned a connected person. So who is a connected person?
So this could be someone like a director who's working for a director of the actual supplier. So it isn't just the direct supplier. Again, it's the government trying to widen the scope of the rules.
So, right, it goes a lot wider than, so they're looking at the status of the supplier and also their directors.
Yeah.
What about parent companies? Are they looking at the status of parent companies as well?
Yeah, so they're also including the parent companies in this.
Okay.
So, yeah, it's definitely something that suppliers need to be aware of.
Okay. And what about subcontractors?
So subcontractors will class as an associated person.
Okay.
So we'll come on to that within our scenario. We'll sort of set out how that would work in practice.
Okay, let's talk through a scenario to see how the exclusion regime is going to work in practice.
Yep, okay, so picture the scene. A local authority is seeking to procure an above threshold contract under the new rules, under the new Procurement Act. So it will be for cleaning services. The tender is being conducted under the open procedures, and the bidders have completed all of the information on the new central digital platform. One of the bidders is a company called Clean & Co. So they are hoping to rely on a subcontractor called Laundry & Co. to complete their bid.
Okay, so my understanding is that when Clean & Co. has uploaded its information on the central digital platform, it sends a note to the contracting authority to say that it's completed its response.
Yeah.
Contracting authority then goes to have a look at the response and take it from there.
Yeah, so if we work through each sort of stage of the scenario, we can sort of put it into practice. So the first thing, the most important thing for contracting authorities to be aware of is that they need to check the debarment list at the very beginning.
Okay.
To check whether any of the suppliers are on this list. So in this instance, Clean & Co. aren't on the list, but in their bid response, one of the directors has a previous competition law infringement offence. So as we know, this is a mandatory ground for exclusion. So what the local authority can do is disregard their tender, and before they do that, they have to notify Clean & Co. that they're going to
Oh, so is this to give Clean & Co. an opportunity to make representations?
Exactly.
Okay.
Yeah. So at the point where the local authority disregards the tender, they then have an obligation to actually notify the Cabinet Office that they will be disregarding their tender on the grounds of a mandatory exclusion ground.
And just to clarify that a bit, so you've said that a competition law infringement is a mandatory ground. So in this case, the director of the company has been found to be in breach of competition law.
Yeah.
So is there any possibility of going back and making representations to say why they shouldn't be excluded?
So there are some things called self-cleaning measures.
Right.
So we do have these in the current regime.
Yes.
This sort of gives the supplier a chance to, like you say, make representations and sort of prove that this is no longer relevant, basically.
Okay.
So something that the local authority could take into account is how long a time has passed since the offence.
Right.
Or if they've changed their practices or increased reporting, or even if they've sort of paid a penalty. It sort of shows that they've had the offence and then learnt from it and changed.
Right, that makes sense. But in this instance, I think you were saying that we're working on the basis that the local authorities decided to exclude Clean & Co.
Yeah, they would notify the Cabinet Office, and then the Cabinet Office then decides whether they start an investigation into the supplier to basically check whether they should be excluded or not. So just as a practical point here, it's really important because the Cabinet Office can actually ask the local authority to provide documents, audit trails, things like that to sort of back up why this supplier should be excluded. So yeah, make sure you're keeping good records.
Okay, that's a really good tip.
Yeah, so if the Cabinet Office then decides that they should be excluded, we then enter into an 8 working day debarment standstill period.
Okay.
So within this time, the supplier can actually appeal the decision. again, if the appeal fails, then they will finally be classed as an excluded supplier and be placed on the debarment list.
And what's the effect of being placed on the debarment list?
Well, it's obviously a public list.
Yeah.
So it's not great for reputation, especially for sort of small businesses who sort of rely on these big contracts. Also, if you're on the debarment list, you can't bid for any public contracts.
And how
within
long's that
time.
for?
It's 5 years.
A 5-year period?
Yeah, so
right.
it could be really detrimental to,
Okay.
like we say, a smaller business.
Okay, all right. But as you said, there's the opportunity for somebody who's threatened with
Yeah.
debarment to appeal.
Yeah, and it's
that
not
process.
just an instant decision, you know, it's a long process. So yeah, they do have a chance.
Okay, so we looked in this example at somebody whose director was in breach of competition. Or what would the scenario have been different if, for example, Clean & Co. had a performance issue?
So interesting. So obviously, Clean & Co., if they had a performance issue, this is classed as a discretionary exclusion ground. But it's only classed as a discretionary exclusion ground if Clean & Co. have failed to perform the contract, they're notified that they aren't performing and are given a chance to sort of rectify. And at that point, they still don't rectify.
Okay.
Only at that point, it would be classed as a past performance issue.
Right.
Similarly, if they've had a past contract which has resulted in a termination or a settlement agreement, something like that, that would be classed as discretionary exclusion ground.
This is the new widening
Exactly.
of the ground that's been introduced to say you don't have to have a contract terminated, you have to have been given the opportunity to rectify a performance and then not done it.
Then still don't do it.
So it's easier for a contracting authority to exclude on the basis of past
Yeah,
performance.
exactly.
I see. Yeah, okay.
And then obviously, because this is a discretionary exclusion ground, the contracting authority can disregard the tender, but they aren't obligated to do so.
Okay.
So that's the key
And do
difference
the rules
here.
on self-cleaning still apply
Yeah.
that we discussed earlier?
Yeah.
Okay.
So they still apply, so the supplier will still have a chance.
Okay, so we've talked about the process that the local authority has to follow in deciding whether or not to exclude Clean & Co. But you also mentioned that the rules apply to key subcontractors. So can you talk me through that process as well?
Yeah, so like we've said before, we're sort of widening the scope of the exclusion rules. So the local authority would have to sort of go through the same process that we did before with the key subcontractors.
Okay.
So, for example, they'd have to check the debarment list and see whether Laundry & Co. were on there as an excluded supplier or excludable. If they were, then the local authority would have to sort of give the lead supplier the chance to replace the contractor.
So the fact that a supplier has put forward an excluded or excludable subcontractor is not fatal to its bid. It's got the opportunity then to bring in a new subcontractor.
Yeah, they have a chance to replace them, and if they do and everything else is fine, they can proceed with the contract.
Okay.
But if they don't choose to replace the subcontractor, then both the subcontractor and the supplier will be classed as excluded or excludable.
Big changes, quite a lot of extra work then in terms of the administrative burden for contracting authorities.
Yeah, there really is. Like we said, throughout this, there's a lot of stages where it's going to be vital that you've kept a good audit trail and kept good records because they might be called upon by the Cabinet Office.
So have you got any other top tips for contracting authorities?
There are a couple of top tips. So I think the key one is to just make sure you check the debarment list as your very first stage. Another one is to make sure everyone sort of in your team is up to date with the central digital platform when it goes live. Also make sure that everyone in your team knows about the reporting and notification requirements, definitely, and keep good audit trails. There's a potential that maybe there's going to be an increase in challenges from disgruntled suppliers.
Absolutely.
Yeah.
That's right, yes.
So if they think that they shouldn't have been excluded, obviously that's going to have a massive detrimental impact on their livelihood, basically. So it's really important that if you think a supplier is excluded or excludable, you have the sort of documentation and decisions to sort of back that up.
And to show that you've gone through the process and to set out your justifications.
Yeah, exactly.
Great. Thank you very much, Isabel. Thank you very much everybody for listening. And as always, if you've got any feedback or comments on the podcast, please don't hesitate to get in contact with either myself or Isabel.